Polity and Governance, that is the current affairs of polity and governance of the month of November 2023. So, our first topic is electoral funding. Why is it in the news? Recently, the Supreme Court directed the Election Commission of India to submit data on the electoral bonds received by political parties till September 30, 2023. Okay, so let me make this a little bit clear to you all that in 2019, while hearing the Association for Democratic Reforms ADR petition against the electoral bond scheme, okay, the SC asked the ECI to submit data on electoral bonds received by political parties. ECI received status reports from 105 parties. ठीक है, दैट इज़ उन्होंने जब इलेक्टोरल बॉन्ड स्कीम के रिलेशन में जब इलेक्टोरल बॉन्ड के लिए पार्टीज से जब स्टेटस मांगा तो 105 parties gave it, but at the same time State Bank of India has revealed that only 25 parties have opened the bank accounts necessary to receive electoral bonds. Okay, so what is wrong over here is that 25 political parties का ही सिर्फ बैंक अकाउंट है. Okay, and 105 parties are showing here the status reports. And according to the data collected by ADR, 69% of the total income of the political parties during the 11-year period has been through the unknown sources, right? In sources kuch ata pata nahi hai. So I hope you all are able to correlate and understand this thing as well. Now let's have a view of the concerns related to the electoral funding. Okay, so impacts of such funding, let's look here. Results in rise of demand of black money, right? Black money increase होने के बहुत chances बढ़ जाते हैं क्योंकि फिर कोई भी जिसके पास पैसे हैं, the person who is having a lot of money, even though he is not ethically the right person, he is not having the right attitude, the parties can take money from them and they would give them a chance to come at the front page, right? And the candidates who can finance their own elections, right? जैसे जो लोग बहुत पैसे नहीं दे सकते but they are very good at doing service and giving service to the people, they will not get a chance because they are having shortage of finance. And the others, like the goons who are actually not the deserving ones, will get a forefront here. And the next is, जब गलत तरह के लोग सामने आएंगे तो क्या होगा? It will distort the level playing field. Of course, जब हमारे पास अच्छे लोग ही नहीं आएंगे तो हम एक कॉम्पिटिटिव एटमॉस्फेयर, एक अच्छा एटमॉस्फेयर नहीं कभी क्रिएट कर पाएंगे और हमारी पार्टीज़ में मेंबर्स भी would not be that efficient and good enough. And definitely then criminalization of politics would take place. Like the so-called criminals and goons would come here in the face of the political parties. So that would definitely be, the cost of it would be paid by the people only. Now, this would also create huge expenditure. जब ज़्यादा पैसे आने लगेंगे, when a lot of money from these places would be coming here, then what will happen? The money would of course get circulated and then it would become like most expensive election year anywhere. This was in Lok Sabha 2019 elections and the same would take place again, right? So now disrupts level playing field, we have already discussed about it. Now increased cash transactions, of course black money मतलब increase in cash transactions ही होता है. And then it causes difficulty in tracing the sources of funds, increasing corruption and reducing transparency, right? जब हमें किसी सोर्स का पता नहीं है कि पैसे एग्जैक्टली आ कहाँ से रहे हैं, so that of course hinders transparency, and increases the chances of corruption. एंड ऑफ कोर्स पैसे तो सबसे ज़्यादा कॉरपोरेट सेक्टर में होते हैं, राइट? सो कॉरपोरेट डोनेशंस ऑफ पॉलिटिकल पार्टीज हैव ऑल्सो बीन increasing too much these days. Now let's see what are electoral bonds. Well, we should have seen this earlier, but now, okay. Electoral bonds are interest free bearer bonds or money instruments that can be purchased by companies and individuals in India from authorized branches of State Bank of India. दैट इज़ ये जो इलेक्टोरल बॉन्ड्स होते हैं ये इंटरेस्ट फ्री बेरर बॉन्ड्स होते हैं और ये मनी इंस्ट्रूमेंट्स की तरह होते हैं. आप इसको क्या करते हो, आप एसबीआई की ब्रांच में, एक ऑथोराइज्ड एसबीआई की ब्रांच में जाके और इसे परचेज करते हो. And this was introduced in 2017 and 18, sold in multiples of rupees 1,000, rupees 10,000, rupees 1 lakh, 10 lakh and 1 crore. And definitely the extent of pros and cons is equal over here. So they promote transparency, and these are the benefits, right? They promote transparency. Identity of donors remains confidential, right? Now next is all transactions of electoral bonds are carried out via checks or digitally. तो ये cash को तो it stops the flow of cash over here. And next is concerns associated with it are lack of transparency regarding the source of funds, right? Who is exactly paying how much and getting those electoral bonds? That is the main thing which we should also be aware about. And shell companies can also be used to fund political parties, right? जो गलत तरीके से पैसों को यहाँ पे इन्वेस्ट कर दिया and they are earning through different means and methods, and then they come and invest in these political parties as a way of bribery also, you can take it, right? So let's look into the way forward. And state funding of elections, transparency, of course it is one of the important way forward. Proactive disclosure, tax exemption, bringing political party under the ambit of RTI, right? जब RTI वाला केस हो सकता है, then we would be able to find out the information as to how much the party is paying, how much they are getting, and who is paying how much, right? By the way, ECI has recommended that tax exemptions would be awarded only to those parties which contest and win seats in Lok Sabha Assembly elections, right? And ECI has also recommended that details of all donors who donate above rupees 2,000 be declared in the public domain. So this is a good thing as well. And the mode of payment can be declared by the parties, and transparency should also be there, which can make things easier and better. Now moving on to electoral literacy, ECI, that is Election Commission of India, has signed an MOU with the Ministry of Education to bring electoral literacy to classrooms across the country. Well, if I talk about this, when we were in the school, we had very little idea about these elections and all that, right? So it's a good step. Definitely it's a good step. Now let's see how important is it to increase electoral literacy. First of all, we should educate children about election process, since childhood and importance of voting are very important, right? Now it helps in smooth conduction of election in a diverse country like India, right? When children of today's era would be aware about all these things, and when they grow up, it would not be an issue to make them understand as to who they should go for, whom they should vote, and the other things as well. Now, address urban and youth apathy leading to better electoral participation. Of course, people are not that much curious about knowing about the good parties and going to give cast their votes, not give cast their votes. So, when the children would be aware about all these things, definitely we would produce good ethical electoral participation and, in effect, strengthening democracy as well. So, for this, we would be integrating voter education and electoral literacy into the curriculum. Starting from class 6 to 12 in all schools. Electoral literacy includes information on government, that is सरकार के बारे में जानकारी रखना, principal social, economic and political issues that is the nation is facing. हमें लोगों की दिक्कतों के बारे में भी पता होना चाहिए, right? अगर हमें लोगों की दिक्कतों के बारे में नहीं पता होगा तो how will we decide that the government is playing its role wisely or not? Right? The value of democracy and equal rights of women and men, among others. And of course, like, since school is a basic unit where children go and learn a lot, it's like the basic structure of a person's life, even because after home, school is the second social place which plays an important role in everyone's life. So, NCERT will introduce and update textbooks to include content on electoral literacy and will advise state education boards and other boards to follow it. Some initiatives like voter awareness forums in departments, private organizations, and institutions, electoral literacy clubs, new voter in colleges and universities, electoral literacy clubs or Chunav Pathshala for those outside formal education system, and electoral literacy clubs future voters in secondary and senior secondary schools, right? So these can be made to influence the mind of the kids so smartly and nicely that they don't face any problem in the upcoming elections when they grow up, when they are the one amongst the voters. So of course for that we need good teachers training, like the way we have the mission Karma Yogi, right? So we can have the something of the same sort for the teachers as well. And campaigns, right? Regular campaigns can be organized by the state election commission to enhance electoral literacy among the masses, increasing funding and coordinating with NGOs and Gram Sabhas to augment electoral literacy programs in the rural areas, right? जितना भी पोर्शन, जितना भी काम होता है हमारा रूरल एरिया से रिलेटेड, ऑफ कोर्स पंचायत एंड द ग्राम सभा प्लेज अ वेरी इंपॉर्टेंट रोल इन इट. Now coming to the next topic, role of governor, right? तो ये तो कुछ ऐसा सीन हो गया है कि हमारे 3 states which are Kerala, Tamil Nadu and Punjab, I hope this you can see this in this rough chota sa map, have moved the Supreme Court against their respective governors. तो ये तीनों states हमारे लेके गए हैं अपनी शिकायत गवर्नर अपने अपने गवर्नर के अगेंस्ट दैट टू द सुप्रीम कोर्ट दैट द पेंडिंग द बिल्स आर पेंडिंग इन द स्टेट्स. द गवर्नर हैज़ येट नॉट अप्रूव्ड मेनी बिल्स एंड दे आर पेंडिंग. तो केरला की जो गवर्नमेंट है वो कह रही है कि inaction on the part of governor in relation to 8 bills passed by the assembly of these. Some bills have been pending with the governor for more than 2 years, right? 2 साल से भी ज़्यादा के समय से वो bills pending हैं. In Punjab, 3 money bills were withheld by Punjab governor, and Tamil Nadu petition mentions 12 bills is pending with the governor. अभी तक वो 12 bills governor के पास ही हैं. Apart from delay in approving the transfer of investigation to the CBI in various cases, right? So it's a major issue, of course, and that is why they have moved the Supreme Court. So constitutional provisions for governor. Now, Article 200 gives the assent of the governor is necessary for a bill to become a law. Right? Central level पे किसका होता है? Yes, the president. Right? Central level पे we need the consent of the president for a bill to become an act. And at the state level, it is the governor who plays this role. So in this regard, the governor has been given some options, right? Give assent to the bill becomes a law. अगर उसको अप्रूव कर दिया तो वो बिल लॉ बन जाता है. Now withhold the assent, the bill fails to become a law. Of course, जब वो पास नहीं कर रहे हैं, then it will not become a law. And here he passed, so it became a law. Now, return the bill for reconsideration of the legislature as soon as possible. वो वापस चला जाएगा when? Then the state legislature passes the bill in its original shape or in a modified form. The governor has to give the assent to reenacted bill. पर अगर स्टेट लेजिस्लेचर ने बिल को पास कर दिया वैसे ही जैसे वो पहले आया था, तो then the governor has to, or even if they have changed also and it goes again back to the governor, then he has to give his assent to the reenacted bill. But the main thing is here is that the constitution does not lay down any time limit within which the governor is required to return the bill for reconsideration. It only insists on as soon as possible, right? And then reserve the bill for the consideration of the president. So the president can give either his consent or withhold the assent. President may direct the governor to return the bill. आप वापस कर दो state legislature को. And such bill, if reenacted by the state legislature with or without amendment, is presented again to the president. Now, the bill passed by the state legislature can be obligatory if it endangers the position of the state high court. Okay. Now, let's see that the governor can also reserve which kind of bill for the following nature. Right? Now, ultra vires, that is against the provisions of the constitution. अगर वो संविधान के हिसाब से नहीं है, then definitely the bill can be reserved. Then opposed to the directive principles of state policy. अगर वो directive principles of state policy के साथ synchronize नहीं कर पा रहा है, then of course against the larger interest of the country, अगर वो जनहित के लिए नहीं है तो of grave national importance, dealing with compulsory acquisition of property. अगर वो property के ऐसे compulsory acquisition से related है, ज़बरदस्ती से हम उसे ले रहे हैं, तो then of course it is of great concern. And discretionary powers. Article 163 states that except when required to exercise his/her functions in his/her discretion, the governor is bound by the aid and advice of the council of ministers. ठीक है, तो बहुत अगर उनके अंदर उनका बहुत इच्छा है कि नहीं भाई हम नहीं पास करने वाले, ऐसा हम नहीं करने वाले, आप कुछ भी कर लो, हम नहीं करेंगे, then it is something else. Otherwise, the governor is bound by the aid and advice of the council of ministers. If any question arises whether the governor is required to act in his/her discretion, the decision of the governor in that regard is final. Okay. Now let's see the recent judgments regarding role of governor. So it's not that recent even. Well, S.R. Bomai case. The court held that the governor's power should be exercised in rare and exceptional circumstances and that the subjective satisfaction of the governor should be open to judicial review. Right? इससे क्या समझ में आता है? अब रोज़ रोज़ गवर्नर अगर अपना पावर ऐसे ही यूटिलाइज करने बैठ जाए, देन ही वुड नॉट रिमेन like dignified in the manner in which he should be. राइट अगर रोज़ रोज़ आप एक ही चीज़ पे अपना टाइम इन्वेस्ट कर रहे हो वे and that too you're required in other places as well, right? So that's not wise enough also. And that the subjective satisfaction of the governor should be open to judicial review, so it can definitely be taken out for judicial review, right? Now Shamsher Singh case 1974, the Supreme Court held that the governor does not exercise their discretionary powers with withholding assent or returning a bill to the state legislature. They are required to act as per the advice of the Council of Ministers. ठीक है, यहाँ पे तो इन्होंने पूरा अलग ही स्टेटमेंट दे दिया था that they cannot exercise their discretionary powers of withholding assent. मतलब वो बिल को withhold करके रख ही नहीं सकते, उनको Council of Ministers के accordingly ही काम करना चाहिए. Now recent judgments, State of Punjab case. If a governor decides to withhold assent to a bill, she has to return the bill to the legislature for reconsideration. उसको वापस करना होता है, गवर्नर को उस बिल को वापस करना होता है लेजिस्लेचर को रिकन्सिडरेशन के लिए. Such bill cannot be kept with the governor indefinitely. उसको आप आराम से कभी जब तक मन करे तब तक के लिए नहीं रख सकते हो. Now Supreme Court observed the governor that governor has only 3 options as per Article 200. या तो assent दे देना है, या तो withhold करके रखना है, और referring to the president, and that after exercising any of these options she cannot then exercise another option. ठीक है, इनमें से कुछ चूज करने के बाद then he cannot go for anything else. Now vice chancellor case, SC underlined the governors acting in their statutory capacity as university chancellor are not bound by the aid and advice. अब वो किसी भी काउंसिल ऑफ मिनिस्टर की एड एंड एडवाइस से बाउंड नहीं है, मतलब ऐसा ज़बरदस्ती वो नहीं कर सकते कि नहीं हमें काउंसिल ऑफ मिनिस्टर्स ने ऐसा कहा है सो वी हैव टू डू इट. Tamil Nadu governor case. So SC stated that governor cannot refer to the bills to the president after the assembly has reenacted the bills following the governor's declaration of withholding the assent. इसका मतलब सीधे सीधे ये है कि SC ने ये भी बोला कि गवर्नर जो है कैन नॉट रिफ़र द बिल्स, वो वापस से उस बिल को वो उन बिल्स को रिफ़र नहीं कर सकता प्रेसिडेंट को ले जाके, जब उन्होंने मना कर दिया था कि नहीं आई विल बी विथ होल्डिंग द असेंट टू दिस बिल, और वापस कर दिया था जब मतलब उन्होंने उस बिल को, देन ही कैन नॉट गो टू द प्रेसिडेंट विद द री-इनैक्टेड बिल. मतलब जब उस बिल में वो चेंजेस ले आए और चेंजेस कर दिए गए, देन ही कैन नॉट गो विद दैट बिल टू द प्रेसिडेंट. ओके, now various issues concerning governor's role are pending decisions. of course ये फिर बहुत ही ज़्यादा कॉन्स्टिट्यूशनल डेडलॉक क्रिएट करता है और पार्लियामेंट्री डेमोक्रेसी को भी डिसरप्ट करता है. now political interference. Of course, there have been instances where governor has been accused of political bias, क्योंकि लोग कहते हैं कि हाँ governor is favoring the political parties and all that. Now administrative inefficiency, friction between governor and state government, especially where there is political difference, जहाँ पे मतलब the governor is of some other maybe the supporter of some other party, or maybe like he's coming from some other party or something of that sort, and the ruling party of the state is some other one. So that definitely creates a conflicting situation there. Now burden on judiciary, of course. अब हम हर चीज़ में अगर सुप्रीम कोर्ट के पास झंडा लेके पहुंच जाएंगे कि नहीं, we want this to be sorted out by you only, you look into this matter, then definitely it is going to pile up the cases and become a burden for judiciary as well. Now way forward, recommendations of different commissions. So Sarkaria Commission, Panchi Commission and Venkatachalya Commission. So it is only under rare circumstances that governor may exercise this discretion. ठीक है, ये बहुत वाइज स्टेटमेंट है कि हमेशा हर बार अपने मन से कुछ भी नहीं कर सकते, बट ही हैज़ टू be very rare in exercising his discretion, right? And where they feel that the provisions of the bill will contravene the provisions of the constitution, जब वो bill के provisions constitution के साथ tally नहीं कर रहे हैं, then therefore should be reserved for the consideration of the president. मतलब अगर बहुत ऐसी स्थिति आ गई कि अगर वो बिल जो भी मतलब अप्रूवल के लिए वेट कराया गया है उसे, अगर वो कॉन्स्टिट्यूशन के प्रिंसिपल्स के साथ नहीं मैच कर रहा है, नहीं जा रहा है, देन ओनली द बिल शुड बी टेकन फॉर द कंसिडरेशन ऑफ द प्रेसिडेंट. ऐसे थोड़ी है कि रोज़ रोज़ बस मन किया तो यू आर विथ होल्डिंग इट, एंड यू नो लाइक इट शुड नॉट बी वेरी फ्रीक्वेंट एंड so easy kind of thing. Now Panchi Commission, governor should take a decision with respect to a bill presented for his her assent within a period of 6 months. ऐसे हर रोज़ अगर लेके, सपोज इफ़ आई गिव यू एन एग्जाम्पल ऑफ दिस कि आप किसी स्कूल में टीचर हो और अगर आप बच्चे को एक दिन लेके जाओ प्रिंसिपल के पास, फिर आप उसको बहुत डराओ, अगर वो डर के और संभल रहा है, अगर उसके अंदर वो रिस्पॉन्सिबिलिटी आ रही है कि इफ़ आई विल नॉट बी डूइंग थिंग्स इन अ राइट मैनर, आई विल बी टेकन टू द प्रिंसिपल again, then he would definitely feel ashamed or feel the responsibility, that sense, and would stop doing the wrong thing. But if you take on carrying him every second day, then that would not make an effect upon him. So things should be done officially in this manner, but not in a very frequent manner, right? So governors are expected to be independent and to act in a manner devoid of any political consideration. उनको पक्षपात नहीं करना चाहिए. The governor should have a fixed term of 5 years and removal should be through a resolution passed by the state legislature. ठीक है. Now next one is the governor should make use of the advice of the council of ministers in the day-to-day administration of the state. ये सबसे सिंपल और सीधा सीधा कि गवर्नर को अपने काउंसिल ऑफ मिनिस्टर्स की एडवाइस भी लेनी चाहिए और उसके हिसाब से अपने डे टू डे एडमिनिस्ट्रेशन में काम भी करने की कोशिश करनी चाहिए. Now let's come to the next topic, special and local laws, right? Now recent tabling of bills on criminal laws has kept special and local laws away from the ongoing reform process. Now let's see what are special and local laws. So a special law is a law applicable to a particular subject covering specific issues, whereas a local law is a law applicable only to a particular part of India. So simply it is very clear over here that special law जो है, ठीक है, वो एक पर्टिकुलर सब्जेक्ट, ये एक सब्जेक्ट होगा कोई, उसके ऊपर होगा, इम्प्लीमेंट होगा और वो पूरे इंडिया में कहीं पे भी हो, राइट? लाइक UAPA, ठीक है, अनलॉफुल एक्टिविटीज़ प्रिवेंशन एक्ट, ठीक है. बट लोकल लॉ, लोकल से ही आप समझ जाओ, लोकल मतलब उस एक पर्टिकुलर जोग्राफिकल एरिया का मे बी. सो इट इज़ अ लॉ एप्लीकेबल ओनली टू अ पर्टिकुलर पार्ट ऑफ इंडिया. एक पोर्शन में, इंडिया के एक एरिया में ही सिर्फ वो एप्लीकेबल होगा. लाइक महाराष्ट्र कंट्रोल ऑफ ऑर्गेनाइज्ड क्राइम एक्ट 1999. Now, cognizable crimes are broadly categorized as those falling either under the IPC, that is Indian Penal Code, or under the special and local laws. ठीक है, चलो let's see what are cognizable offense first. So they are the one which an officer is in charge of a police station may investigate without the order of a magistrate and effect arrest without warrant. ठीक है, फिर उनको ज़रूरत नहीं है, एक पुलिस स्टेशन में जो ऑफिसर है वो ऑफ कोर्स उस केस पे जाके, उस प्रॉब्लम पे जाके इन्वेस्टिगेट कर सकता है. नहीं, डज नॉट नीड द वारंट फ्रॉम और द ऑर्डर ऑफ अ मैजिस्ट्रेट टू डू दिस. Now, Indian Penal Code, so this defines the various criminal offenses. ठीक है, प्रिस्क्राइब्स पेनाल्टीज, मतलब वो अलग अलग क्राइम्स को डिफाइन करता है इंडियन पीनल कोड. फिर उसके लिए पेनाल्टीज भी बताता है कि हाँ, अगर आपने चोरी की है तो आपको चोरी करने के बाद ऐसी ऐसे मतलब पेनाल्टी पे करनी पड़ेगी, एंड एस्टैब्लिशेस प्रोसीजर्स फॉर देयर प्रोसिक्यूशन. Now, CRPC Code of Criminal Procedure is a comprehensive legal code that outlines the procedures and rules for the investigation. कि कौन से procedures और rules आप investigation के लिए यूज़ करोगे, and trial of criminal offences in India. मतलब आपने कोई crime किया है तो आपका trial कैसे हो सकता है. And Indian Evidence Act provides a framework for the admission and exclusion of evidence in Indian courts. कि आप provides a framework कि आप कैसे अपने एविडेंस का एडमिशन या एक्सक्लूजन करा सकते हैं कोर्ट में से. Now let's see the significance of what special and local laws, right? So high case of registration एंड एफिशिएंसी इन एनफोर्समेंट. जब बहुत ही ज़्यादा अच्छा एनफोर्समेंट होने लगेगा तो ऑफ कोर्स, राइट. हाई केस ऑफ रजिस्ट्रेशन, प्रोटेक्शन ऑफ वल्नरेबल ग्रुप्स एंड टेक्नोलॉजिकल एडवांसमेंट्स. Now there is a need for reforms in SLLs, that is under unclear definitions, applicability dilemma, clarity issue, dilution of due process, stringent provisions. And the way forward being separate chapter in procedure, that is all SLLs which seek to criminalize a conduct should find a place as separate chapters in procedures. इनको हम अलग करके mention कर सकते हैं rather than mixing them up altogether. And due process safeguards strengthen the implementation of universally accepted due process values by conducting regular training programs for legal professionals and law enforcement agencies. Now, introduce guidelines or amendments to provide clarity on categorization between क्रिमिनल एंड सिविल रॉन्ग्स. ठीक है, क्रिमिनल रॉन्ग्स कौन से और सिविल रॉन्ग्स कौन से, उनके बीच में डिफरेंशिएशन शुड बी वेरी इजी एंड लाइक इट इंक्रीजेस द एफिशिएंसी ऑफ कैटेगराइजेशन. Now, emerging crimes and threats. So, new types of crimes such as cyber crimes and terrorism constantly are emerging, right? So, reforms are needed to equip legal systems with the necessary tools to address these evolving threats effectively.